Yes, please.
It's a pleasure. It's a pleasure to talk to you. This is one of my favorite radio stations. I used to represent some time back with Alaji Baturi and Alaji Ibi Fusini, and Laji. When you run into your troubles with NC, I really sympathize. I'm glad you're back on air.
Fantastic. Thank you. Thank you. Well, we're discussing this morning a suit that you have put before the Supreme Court. Explain to us why you've decided to take this move and what your objectives are.
Well, Ghana is a nation of laws. I think that most of the actions that we take are guided by laws. When you believe that something is not being done in a lawful manner or is contrary to procedure, you have a duty as a citizen to take the necessary steps to ensure corrective measures are taken, or at the very least, a proper view is taken of what is being done under the current situation. So I think that if you think that something is being done and that thing is not constitutional, you have the responsibility to go to the people who are empowered to do the necessary interpretations and the necessary enforcement, to give them the mandate to seek their mandate to do what is proper. So that is what I have done. I believe certain things that have not been done properly since particularly since the year 2000, when we began to have the phenomenon of ex-presidents in this country. Certain things were supposed to have been done as far back as then. Parliament was supposed to assume certain responsibilities that Parliament has refused to assume. And there's a need for us to finally make an effort, nearly 23 years post facto, to make an effort to get Parliament to do this duty.
And what particular duty is that you're drawing the Supreme Court's attention to in this case?
Primarily, that duty has to do with their oversight responsibility over ex-presidents. You know, Parliament has oversight responsibility over government, but there's a constitutional clause that also gives Parliament oversight responsibility over people who have become ex-presidents of Ghana, and that constitutional provision has been ignored. In fact, it is a very little known constitutional provision that is there in the Constitution, black and white, but most of us behave as if it doesn't exist. It's one of the main fulcrums of my excursion into the Supreme Court. That particular provision is Article 68(2) of the 1992 Constitution. I am seeking a declaration from Parliament, from the Supreme Court, that by that article, former presidents require permission to do a lot of things that they do. Former presidents, in actual sense, and Article 62 becomes wards of Parliament and that sort of thing, so that they are not free as they would like to believe. They are not free to go about doing whatever they want to believe. They come under some level of authority in the People's Parliament.
The particular issue you raise from reading through your release has to do with the former President John Dramani Mahama actually contesting the 2024 elections and holding the position of flag bearer for the National Democratic Congress. I'm correct, right?
It's one of the reliefs, yes.
Okay, so on that particular one, exactly where has Parliament failed?
Let's first and foremost read Article 68(2). It says, the President shall not, on leaving office as President, hold any office of profit or emolument, except with the permission of Parliament, in any establishment, either directly or indirectly, other than that of the state. I'm saying that if somebody who is under this clause goes and gets himself elected as a flag bearer of a political party, which is an establishment, my position of the law is that it requires parliamentary approval.
But then there's a qualifier, office of profit or emolument. You are a member of a political party. Is the office of the flag bearer of a political party an office of profit or emolument?
On the record, I can give you published proof, that Mr. Mahama has been taking money from members of the public. I can give you that one. Number two, how would you and I know that it's not an office of profit or emolument, except the people's representatives are given an opportunity to look into it? Because I cannot sit in the comfort of my office here in the house and say that it's a flag bearer, they pay nothing. And I don't think Radio Gold is qualified to say that the flag bearer of the New Patriotic Party also does not take a salary, or the NDC does not take a salary. It is not in our mouth to say. It is the person who falls under authority who must go to the proper authority and say that I'm going to do this, and these are the conditions. I've gone to Parliament to say that the Speaker of Parliament be compelled. He should be compelled to make sure that the people who fall under authority should put in place the necessary committees, so that somebody who falls under the authority of Parliament, who requires parliamentary permission, who is out there doing what he is doing, comes to Parliament and explains to our representatives in Parliament the exact conditions of whatever is employed in.
Mr. Kuranchie, you have been a parliamentary candidate of a political party before, right?
Yes, sir, twice.
Twice?
Aspirant.
An aspirant?
Yes, please. Yes,
okay. As far as you know, our parliamentary candidates paid. When we're fighting for the job, was it going to be an office of profit?
Do parliamentary aspirants receive contributions?
So that is your definition of profit?
No. Do they receive contributions? It's a profit. It's a profit for a cause. I can tell you on record that I used to receive donations.
So the donations are profit?
It's profit for a cause. You don't take the money and put it in a room. You take it for use.
And that use is for the use of the party to win an election, right?
Let me add this point. Then you continue with your question. How would you and I know unless our representatives are given the opportunity? That is why the clause is there. It's not for you to sit in the comfort of your home and decide that, oh, what I'm doing here, I'm not getting any emolument or anything, so I won't go to Parliament.
But Mr. Kuranchie, you are not just an average Ghanaian. You have been, you are a fairly senior journalist. You are also, like I said, you've contested in a political party. So you are quite highly placed. These are information that I guess that in your work as a journalist, you have some knowledge of, don't you?
What does that mean?
Yeah, some knowledge of whether or not flag bearers are paid or the monies they take are for profit.
It is not in my, further again, it is not in my right to sit in the comfort of my home and say that what I'm doing is the work of an aspirant, a flag bearer. So they receive no profit or no emolument. Once you fall under the appropriate authority, once there is a House of Parliament that the Constitution says you must go to, when you are doing anything in any establishment, then you have the duty to go there. In any case, being a flag bearer is not an end in itself. I think that one, you and I can stipulate. We can easily agree that we are not being flag bearers for the sake of being flag bearers. We are being flag bearers to become president. Now, the question I'll ask you, does the president take emolument? That's one of the reliefs I've taken to the Supreme Court, to make a declaration that when you become president of Ghana, you take emolument. And if he takes emolument, if he's going to target an office that delivers emolument, and he's a former president of Ghana, then clearly he should be before the People's Parliament to explain what it's about.
68(2) ends with other than that of the states.
Yes, please.
Other than that, you are a lawyer yourself. Other than that should mean that is an exception, is it not?
Other than that of the state, yes, it's an exception, yes, please.
So the exception is that if he's holding an office that is of the state, that is excluded from seeking permission from Parliament, right?
That I agree with you, yes.
Yeah. So is the presidency not other than an office of the state?
That is it. It's an office of the state.
So why? So does 68(2) apply?
The process to the road to let the be a Radio Gold and Radio Gold itself are both crucial. I think you would also agree with me on that, wouldn't you?
Mm.
So the processes he's passing through are crucial to the end he gets to.
Mm. So your case is based on an inquiry into whether or not he makes profit or emoluments as flag bearer of the NDC.
As I'm telling you, I can give you published items where he's taking money from members of the public.
With clear objectives.
To become a flag bearer or to be the flag bearer of NDC, that one is out there.
He sought money from people to be flag bearer of the NDC.
You said he sought money. Is that the word you used?
No, you said he sought money. I didn't say sought.
He sought money, yes. He takes money from members of the public.
To become flag bearer?
Yes, please.
When?
Oh, I can give you. If you can give me an email address, I can make it available.
Because I recall the times when he's actually led a fundraising exercise, and it was supposed to support the organization of, I think, the Congress, and also subsequently the parliamentary primaries.
So he was soliciting for funds.
Not for himself, but for the party. Ultimately, he was using his name to solicit funds for the party.
I think there's not much difference between what you are saying and what I'm saying.
And that is what you see as for profit.
He shouldn't be pulling heads over these little things. I can give you instances where people have made donations to him. I believe that some of these donations have been accompanied with pictures to him and some of his staff. So the point I'm making is that the very broad terminology of Article 68.2 leaves very little room. In any case, it is not at our discretion to decide as aspirants and flag bearers that given the position, I sit in the comfort of my home and decide that I fall within an exception to the law. Once this broad terminology is there, it is only right that you make yourself available to the People's Parliament to do what is necessary.
There's another portion where I just wanted you, whether you are not clear on it, because you are asking a question of term, that a term is 4 years. That, what is that question? What's that question supposed to address?
Okay, I am seeking a declaration from our Supreme Court that on a true and proper interpretation of Article 66(1) of the 1992 Constitution, the number of years of a presidential term in Ghana is 4 years. I want the Supreme Court to make that declaration.
So they should declare. I thought that all of us know that.
Because
it's a practice.
There's a popular perception in this country that once you become president, you deserve 8 years. You are entitled to 4 years. You are entitled to 4 years. You do not deserve 8 years. You are entitled to 4 years. And I want the Supreme Court to make that declaration.
Nobody has gone to an election seeking a term of 8 years.
But people, that is the popular terminology, the term out there that within 4 years, I can't 4 years. Within 4 years, I can't 4 years. 4 years can the term is 4 years.
Yeah, so you are. Is that not inviting the Supreme Court into an arena of public discussion?
The Supreme Court into
the arena of public discussion, or
I'm not inviting them. That declaration that I'm seeking does not stand in isolation. It comes along with other declarations.
And then you're also saying that if you are seeking re-election, you must be a sitting president.
Exactly. That's the second relief I'm seeking in the Supreme Court. I believe that the first and second term should be contiguous. The other body of opinion is that it can be disparate. That means that you can be president, go away for 4 years, 8 years, 16 years, 12 years, and come back and have your second term. I believe it should be contiguous. So in between the first body of thought and the second body of thought, there's a lacuna, there's a difference. One believes this way, the other party believes this way. I believe that it should be contiguous. Some people have said that I may be seeking to read the 1992 Constitution, read words into the 1992 Constitution, or that if the constitutional framers had wanted that, they would have put it in the Constitution itself. The fact of the matter is that you cannot. The Constitution is a living document. It grows. No constitutional framer is in the position to make provision for every exact eventuality. You understand?
But the 66-2 you are relying on says a person shall not be elected to hold office as president for more than 2 terms. It didn't say 2 consecutive terms.
That's the point I just made to you. That the framers of the 1992 Constitution are not in a position to provide for every exact eventuality. So you must, when you read a law, you must read the law in sum, so that everything falls in place within the law. I'm saying that if you read those entire provisions, you read them as a cohesive, comprehensive unit, it makes sense for the presidency to be contiguous than disparate.
And ultimately, your objective is?
The objective is what?
What is your objective?
I believe sincerely that Mr. John Dramani Mahama is not eligible to contest election 2024.
Oh, okay.
I believe sincerely.
You believe sincerely, and you want the Supreme Court to agree with you?
I want the Supreme Court to agree with me that, one, he needs to pass through the necessary processes, and two, even if he passes through the necessary processes, it becomes quite obvious, if properly read, that he's not eligible to. In fact, former presidents of Ghana are not eligible to. So, President Kufuor, for instance, is not eligible to contest again to become president of Ghana.
And your basis is the Constitution?
My basis is the Constitution. If unless you would say that former President Kufuor is entitled to become the president of Ghana and can contest again.
No, he served the 2 terms as guaranteed man at 66-2.
Now you see, you are not guaranteed 2 terms. You are guaranteed 4 years certain, 1 term. You are guaranteed 4 years. Every presidential term is 4 years.
Okay, so the 2 terms as is allowed to hold. Allowed to.
That is why
the maximum 2 terms is gone past that.
That is why you now realize that when I said the Supreme Court should declare the 4 years, it was not an exercise in fun. It's not just fun. The Article 66(1).
Because I use guaranteed instead of allowed.
You are guaranteed 4 years. Then I'm saying that you can then contest to get the second term. But if you do not get the second term, you become comparative to President Kufuor.
How?
Because you are an ex-president. Unless you...
And you're saying being an ex-president automatically disqualifies you from seeking your second term?
Unless you quibble with me that he's not a former president.
You are saying being a former president disqualifies him?
I'm saying that being a former president, President Kufuor should disqualify him from contesting again.
Because President Kufuor is allowed to was allowed to contest 2 terms, and he's done that. And he won twice.
He contest the second term when he was in office.
He was allowed to and where is that in the Constitution?
That is why we go for constitutional interpretation.
No, but you must first point out to the Supreme Court where in the Constitution says that.
No form of the Constitution is in a position to provide for every exact eventuality.
And I'm saying that the Supreme Court is doing interpretation, so you must point out to them which article you think agrees with you for them to either agree or disagree with you. Is that not it?
That is why I'm saying that if you look at Article 66(1) and 66(2), read together should lead to a consecutive presidential term. If otherwise, then the person has fallen under Article 68(2). He becomes an ex-president. You see, you must read these entire clauses to make some sense into them, to bring some sense and coherence into them. Otherwise, we will all be all over the place doing all that we like.
Have you heard a suggestion that you are essentially just seeking attention and will be wasting the Supreme Court's time.
And unfortunately, these suggestions have come from very learned seniors in the National Democratic Congress. Yesterday, I was in debate with one of them. You see, a matter has gone before the Supreme Court. People should stop making sociological and political, but it is particularly hurtful when people who are educated in the law decide to look at legal propositions through a politically tinted lens. Somebody sends a constitutional case to a court, and then you wear your tinted political lenses instead of wearing your legal lenses and begin to look at the issue. It is hurtful because you are worth more than that as a lawyer.
And Ken Kuranchie is not wearing an MPP lens.
No. This is not coming out of MPP.
If former President Mahama was an MPP person, you would do same.
But President Kufuor is a defendant in this case.
President Kufuor is not seeking re-election. He's not seeking election.
He's a defendant. I'm seeking a declaration that properly he should fall under the authority of Parliament.
At the end of the day, this is intended to bar former President Mahama from contesting. So President Kufuor is not actually affected. He's just there for formal process.
It's intended to raise him to his position as a former president of Ghana.
Raise him?
Yes.
He's already there.
Fantastic. So he should be there. It's a very prestigious position to be in.
He should stay there and go nowhere else.
He should sit there and do things on behalf of the state. There are a lot to do.
And not contest.
I believe he's not eligible to contest.
Mr. Ken Kuranchie, thank you very much for speaking to us.
It's been a privilege talking to Radio Good. I greet everybody there.
Ken Kuranchie is a senior journalist. He's the editor of the Searchlight newspaper and also the plaintiff in this matter is the man who has taken the matter to court. We have to move on to other things.